unfortunately, even the death of a little baby girl is only worth $50,000 unless you can show that she suffered before her death. One of our biggest cases involved the death of an 18-month-old. The mom was just strolling with her in the stroller, crossing the street. She had the light in her favor. She was in a crosswalk. A driver was making a right turn, and he just didn't see her. And he ran over the stroller. She sustained a skull fracture from the impact. We found out a lot about the driver, that the driver was under the influence of marijuana while he was driving. He had done coke earlier in the day. He had no business driving that truck at that time, and that's why the accident happened. So the problem in New York is, unless you can demonstrate that somebody had sustained pain and suffering, case isn't worth much. So if you can show that somebody died on impact or died without any suffering, technically the case is worth $50,000. That's the wrongful death statute. Somebody died as a result of something that you did wrong, your case is worth $50,000. Our job as lawyers is to find a way to demonstrate that no, the child survived for a period of time and she did suffer before she died. And that wasn't easy to show with the severity of the impact to her head. So we were very, very creative, and we decided on shifting the recovery from the child to the mother, because the mother was allowed to make a claim for emotional distress. So there's a claim called a negligent infliction of emotional distress, and because she was in the zone of danger, she was with her child when it happened and she was exposed to that danger even though she wasn't impacted by the car at all, psychological trauma that she went through as a result of seeing her child die was worth in and of itself millions of dollars, and we were able to get $3.4 million for that claim.